I'm delighted to introduce Jill Welch, partner and chair of Employment Practice Group at Barley Snyder. Jill has an impressive background counseling companies on labor and employment law, developing workplace policies, and representing employees across various industries. Today, she'll provide us with State of the Union on the Department of Labor, covering key updates on wage and hour trends and a new overtime threshold. Without further ado, Jill, the stage is yours.
Good morning, everybody, and thank you for that introduction. And while Kristen was mentioning the need to keep our eye on the state ball, I was shaking my head vigorously here, and then we'll talk a little bit about that. So well done, Kristen. But welcome, everybody. This past 2 months has been a whirlwind of activity. And we had a thing called the election that happened in the middle of it that has really changed perhaps the course of the direction and the priorities of the DOL as we move forward. We've had a significant amount of changes that have been brought about by the courts. I'll talk a little bit about that. And then as the courts move forward, it's very difficult to predict even how that will come out and read the tea leaves because the decisions and the timeline for what is an appeal is going to also be affected by the incoming administration that may completely change the direction and withdraw appeals. They might decide to issue their own new regulations or pare some back. So reading the tea leaves is going to be a little bit difficult here, but we'll do the best that we can for you. And I have to give my disclaimer that none of the information that I'm providing is actually to be considered legal advice. I'm happy to talk offline with you if you do need to delve a little bit deeper into these topics, but this is for presentation purposes only and information purposes only. So what do we know about the new Department of Labor Secretary pick from the Trump administration? Some of you may be following this and have heard in the news that Ms. Chavez DeRemer is the pick for the Secretary of DOL in the upcoming administration. She is a Republican from the state of Oregon, last elected to Congress in 2022, so she was fairly new to Congress. Small businesswoman who founded an anesthesia management company with her husband, who is an anesthesiologist. But what does that bring to the table when we're trying to read the tea leaves of the upcoming agenda priorities for the Department of Labor? Well, she was a surprise pick for some in the GOP because she had she ran on a somewhat pro-union platform, getting support from the Teamsters. And so I want to talk a little bit about the Protecting the Right to Organize, or called the PRO Act, and her support of that. So maybe we can read a little bit into a perhaps dichotomy between a pro-employer direction for the DOL when it comes to focusing more on compliance than enforcement, and yet when it comes to the Department of Labor, a pro-worker agenda that we might see work its way through some of the initiatives and priorities of the Department of Labor. And where we're most likely to see the most immediate impact is going to be on things like the independent contractor rule, the joint employer rule, which I'll go through really quickly, and some of the initiatives coming out of the National Labor Relations Board. So the PRO Act, just to before I leave Ms. Chavez DeRemer, is a very pro-worker agenda put forth by the National Labor Relations Board. It's still in committee. It hasn't been released yet. But the guts of that act would authorize the National Labor Relations Board to assess monetary penalties for each unfair labor practice charge that's been litigated against an employer. It allows the National Labor Relations Board to seek injunctive relief to reinstate employees while the case is pending, as opposed to waiting until the case is over. It amends the National Labor Relations Board and the Act to incorporate the ABC test, which is a much more lenient test that comes out of the state of California when determining whether folks are employees versus independent contractors. Why does the National Labor Relations Board care? Because those people can vote in an upcoming election. It claws back a little bit an employee's ability to waive their rights to engage in class and collective action litigation. And there are some other notice provisions that are out there. But all in all, it's a very pro-worker act, and we'll have to see if Ms. Chavez DeRemer, as the new Department of Labor Secretary, tries to navigate and straddle that line of support that she got from the union community and the agenda of the GOP. So with that, I want to transfer into the topic of wage and hour litigation. This is part of what I do. I work with companies and employers on wage and hour litigation and hopefully on measures and training to avoid wage and hour litigation. But it is a significant concern from in-house counsel and from major companies across the spectrum of industries. And we saw in 2022, in 2020, 2021, an increasing trend in wage and hour litigation. And then all of a sudden in 2023, we saw a significant drop off. And so it'll be interesting to see whether that drop off continues into 2024 or not. But perhaps by no surprise, Pennsylvania is one of the top ranked cases with a number of cases being filed. And why are these cases so important to and a concern to our companies? Well, when the Department of Labor goes in and does an audit and they knock on the door and say, we're here to inspect your records and your files, based on perhaps a disgruntled employee coming forward with a complaint, roughly 70% of the time, employers are getting something wrong. And the Fair Labor Standards Act has been in place since 1938. And so you would think that by now, we could get all of our ducks in a row and everybody could get everything right. But it's a really complicated set of regulations and laws that are even extended and interpreted by the courts in various ways. And so it really is a complicated area of the law. And that's one of the reasons why wage and hour litigation is such a concern. The other reason why it's such a concern, and I'll talk a little bit about that next, is because where there's one employee, there are often multiple employees affected by our payroll policies and our pay policies, our practices, et cetera. And so what that means is that while an individual might bring a claim, oftentimes when they visit an attorney, those claims grow into and erupt into class and collective action litigation. And so that's why these cases are very difficult to manage. And oftentimes they're not insured under our employment practices liability insurance. So it is one of the top concerns for in-house counsel and companies going into 2025. Now, the positive is we're going to see the Department of Labor under the Trump administration focusing more on compliance than on enforcement. So we might see some funds being shifted away from enforcement and numbers of folks out on the street knocking on doors and more into a compliance effort. In terms of the industries that are being targeted with wage and hour litigation, perhaps not surprising, it's those industries with a lot of turnover. So the more turnover that you see, the more likely folks are to visit with plaintiffs' attorneys, to visit and to talk about their wages and talk about the potential for wage and hour litigation resulting in class action litigation. So the top industry is healthcare, comprising over 13% of all of the federal Fair Labor Standards Act litigation filed. After that is business services. After that is retail, and then construction. Retail and construction, retail because you have a lot of turnover, construction because there are a lot of independent contractors being used in that industry. So we see a lot of misclassification in the construction realm. And then in business services, we see a lot of misclassification on the exempt, non-exempt issue, which we'll talk a little bit about as well. So those are the top industries that we're seeing. And in the Eastern District of Pennsylvania, the reason why a lot of folks do tend to file here is because the juries are very employee friendly in, perhaps not surprisingly, the core area of Philadelphia, which is where the Eastern District of Pennsylvania has one of its federal courthouses. And the Department of Labor also files suit on behalf of aggrieved individuals who have lost wages. Under the Biden administration, we heard that named wage theft. It might have a different moniker under the Trump administration, but these wage theft cases are also brought by the Department of Labor, and they've recovered in 2023 approximately $212 million in back wages. They conducted over 20,000 compliance actions, which actually is slightly down from the previous years. But again, we might see that shift away from enforcement and more into compliance to assist individuals with complying with the laws. And so I spoke a little bit about wage and hour litigation and why it can be so tricky and so complicated. In wage and hour litigation, again, where there's one, there's usually many, and that leads to class and collective actions, which can be very expensive to resolve. And the reason that we know these statistics and the reasons that we know the settlement amounts, which I'll go through some of the cases recently with you, is because it's public record. And in order to resolve a wage and hour claim, you do need to get either the Department of Labor approval or a court approval. There's been some movement to try and allow for private settlements, but for the most part, these settlement agreements and the amounts that are the cases are being settled for become public knowledge. Now, in the lifetime of a class action, wage and hour class action, collective action, there has traditionally been a two-step process where you have to come forward, the plaintiff has to come forward with enough evidence to say, yes, there's enough the glue that can bind me with the rest of this group of employees. And if it's a low threshold, and once you succeed as a plaintiff in that threshold, then your case moves into class action. It's called a conditional certification of the class. And that's a significant leverage point that plaintiffs have towards settling these kinds of cases. So if they can get over that initial hurdle of conditional certification, then that really does lead many of these cases to being resolved in a settlement. What has been the success rate of plaintiffs? Now, we've seen in the prior years, in 2022, we saw a success rate of practically 85% of conditional certification and collective actions being granted. And so a lot of employers are not really, putting up a fight in that conditional certification, and they're really kind of rolling up their sleeves and getting down to the nitty-gritty and seeing how we can resolve that. That number is trending down. In 2023, we saw that success rate go down a little bit to 75%. And perhaps the reason is because we see the courts saying, you know what, this isn't an automatic ticket. You need to show a little bit more proof in this conditional certification phase. And so even the Supreme Court is kind of clawing back a little bit on this automatic ticket success rate for conditional certification. So we are seeing a little bit of movement in that in the courts. So it's not necessarily a fait accompli where employers are just automatically saying, okay, we'll agree to conditional certification and then get towards trying to resolve it. Again, in terms of settlement, we are seeing in 2022, we saw a number of cases settle in the wage and hour litigation phase. Talk about that next. So the settlements amount in 2023 were trending upwards. Nearly $500 million was the average value of the top 10 wage and hour class action settlements. So these are expensive cases to litigate because they involve so many people for large employers. The settlement values on average are all over the map. It really depends on if you have a blockbuster case coming forward. We did have a couple of those in 2023 that pushed that settlement value up. Sure, let me get to the next. There we go. So a little bit about federal developments, switch gears here. And you've all heard it, this is the big one. The DOL Final Overtime Salary Rule was vacated. So as you heard, in July of this year, the salary threshold for the white collar exemption to apply, meaning the folks who are in the administrative, the executive, the professional, the computer, the highly paid executives, the salary threshold, which is one piece of the puzzle, it's half of the puzzle. I'll talk about the other half later, which is the duties test. But the salary threshold increased on July 1 from $684 per week, or an equivalent of $35,568 annually, to $844 per week, or an increase to $43,888 annually. And that is water under the bridge at this point in time. Although there were many legal challenges being brought, that went into effect nonetheless. And we were scheduled on 1/1/25 to have a second bump where the minimum salary threshold was going to go up to $1,128 per week, or the equivalent of $58,565 annually. And a lot of our clients, small businesses, nonprofits, while that 43,888 number wasn't that difficult a pill to swallow, the next bump was going to be problematic. And we were going to see companies really have to look at, boy, can I really streamline the exempt duties for my truly exempt people, take some of those duties away to decrease the number of hours of folks are working if they have non-exempt duties, reclassifying people. Do I need to hire temporary workers or part-time workers to fill in the gaps? So there was a lot of behind the scenes effort going into planning for this second bump. Then along came the state of Texas versus United States Department of Labor, and they ruled in September that, they ruled on November 26th of 2024, Thanksgiving break, that the final overtime salary rule was an unlawful exercise of the Department of Labor power, and so they vacated the overtime salary rule, going into effect on 1/1/25 nationwide. It was viewed as it was a nationwide injunction, nationwide vacation, and they also vacated the prior 7/1/24 July increase. And so where we stand right now is we are reverting back to that pre-July 1, 2024 amount of $684 per week and $35,568 per year as the salary threshold for exemptions once again. The court also vacated the highly compensated executive salary increase that were going to go into effect, again, reverting back to the pre-July threshold. And there was this kind of automatic escalator provision, which is kind of illustrated by this gentleman who is jumping the coins there. That too was vacated. It was an automatic bump that was supposed to go into effect every 3 years, tied to a formula. And the court said that too was an overreach of agency power, and they vacated that. So we weren't quite sure what the direction was going to be after this. It was a Texas trial court. Was it going to be appealed? Was the agency going to withdraw the rule? And oh, by the way, we've got a new administration coming in. So what are we going to be seeing in the future? We weren't sure whether an appeal was going to be filed, but on November 26th, that's when the appeal was filed by the Department of Labor, currently under the Biden administration. So there's now an appeal pending. What that means in terms of the next steps, the new administration could come in on January 20th and they could withdraw the appeal. The new administration could come in and they could change the rule and put out a new final rule for review and comment, and something that's more in line with the July 1 increase, as opposed to something that's more extreme with the January 1 increase. And the ruling, frankly, the vacation of this rule was a little bit of a surprise to myself and some of the others, because just a month prior to that, the Fifth Circuit Court of Appeals, which is the Court of Appeals of this very Texas court, sided with the Department of Labor in the ongoing long-standing challenge of the 2019 overtime salary threshold increase that went from $455 to the $684 per week, which we're talking about right now. So there was a challenge on the books for that had been going on in the courts for years and years and years. And then finally, a month before this decision vacating the current rule, the Department of Labor said, or the court said, Department of Labor, you do have the authority to impose a salary threshold. It just needs to be reasonably related to the number of folks who are truly administrative, executive, or professional exemptions. And the way that differs from but that court left the door open for what this court did just last month to say that the DOL in this proposal went too far. And they looked at the statistics and they did a significant analysis of how many folks were going to be affected by this rule moving from exempt into a non-exempt category and how that was going to affect the businesses. And when they looked at anywhere north of 30% of folks who would otherwise meet the exempt categories based on their duties tests, all of a sudden having the rug pulled out from under them and no longer being exempt because of this salary threshold, that mismatch between that 30 to sometimes up to 50%, depending on the industry, and the new salary threshold warranted vacating that salary threshold because that was a bridge too far. You can't just sweep 30 to 50% of otherwise exempt people out of the exemption by this salary increase, which nowhere in the regulations is there a call for the salary, a salary threshold. It's a proxy, and it is an exercise of discretion of the Department of Labor in interpreting the regulations. So Texas court said that went too far. We do have an appeal on the books to the Court of Appeals, and just stay tuned as to how that appeal and how the new administration coming in is going to affect that. And oh, by the way, we have a Supreme Court issuing something called the Chevron deference. Now, please don't fall asleep on me here, because Chevron deference is one of those law geek proposals, right? But it's becoming more and more mainstream because you'll hear it uttered by representatives, by the Supreme Court, by judges. And basically, the Supreme Court pulled the rug out on Chevron deference, meaning courts no longer need to defer necessarily to federal agencies when they are putting together their federal agency regulations if the rulemaking and the statutes are ambiguous. And so the courts have carved out a role for themselves in basically crafting whether regulations are going to go forward or not, and whether they're reasonable. So you might hear this term uttered more and more in analysis of the courts and the way that the regulations are going forward. But I did want to take some time, and I was asked to take a little bit of time here to go through the exemptions themselves, because while the salary threshold piece might have been, pulled back a little bit, we still have the duties test, and therein lies a lot of the litigation, a lot of the confusion, and some traction when you get plaintiffs' attorneys coming and bringing these cases forward. So I'm going to quickly go through them. We have white collar exemptions under executive, administrative, learned and created professionals, outside sales, and computer professionals. But oh, by the way, as Kristen said, we still need to look at Pennsylvania law. And in Pennsylvania law, we don't have a highly compensated executive category, and we don't have a computer professional category. So in Pennsylvania, you have to go back and look at these other four categories. The top mistakes that we see here are, just because I'm salary doesn't mean I'm exempt. Just because I have a title of manager or executive doesn't mean I'm exempt. Just because I'm called an administrator doesn't mean I automatically meet the administrative exemption. Just because I'm a supervisor doesn't mean I'm exempt, unless I regularly and direct 2 or more full-time equivalents, and I have the authority to hire and fire or make recommendations in that regard that are given weight. So those are the big issues that we see, mistakes that are being made. So again, we have the salary basis test, which we walked through. It's now set at the level of 684 per week. And if there are any changes to that, we will certainly keep you posted. When it comes to executives, though, what is the duties test? Again, in order to be executive, you have to have a primary duty. At least 50 or more % of your significant essential duties need to be the management of the enterprise or a recognized department. You have to customarily and regularly direct the work of 2 or more full-time employees or equivalents, and again, have authority to hire and fire, or your recommendation in that regard is given particular weight. And then we have the overlay, as we peel back the onion, of the Pennsylvania Minimum Wage Act, where you cannot devote more than 20% of your work hours in a non-exempt capacity, right? So we need to be mindful of that. You need to be a true executive running whatever the department is or running the company. The next one, and this is where we have a lot of litigation, is in the administrative exemption. Again, just because I'm called an administrator doesn't necessarily mean I meet this exemption. There's a couple prongs here that we need to meet. We have to have a primary duty of performing office or non-manual work directly related to management or business operations of the employer or the employer's customers. For example, if you're in the financial industry, Are you working on the employer's customers? In other words, are you working on the business as opposed to in the business of what the business is producing? Cannot be inside sales. So much of our sales now, it can be done inside sales. It can be done over the internet, remotely. If you're working inside sales and you're not out on the road doing the traditional door-to-door almost selling, that's not going to qualify here. You have to also have a primary duty that includes the exercise of discretion and independent judgment on matters of significance. What does that mean? I'll walk through that. And again, we have that overlay of the Pennsylvania Minimum Wage Act of not devoting more than 20% of your work hours in non-exempt work. So these are some of the functions, some of the positions that we see qualifying for administrative: tax, finance, accounting, budgeting, auditing, insurance, quality control, purchasing, procurement, high level, advertising, marketing, strategic planning, government relations, human resources folks, if you're on the call, personnel management, HR, policy making, employee benefits administration. If you're at the negotiating table in a unionized workplace and making those negotiations, that qualifies. But somebody who is an HR generalist, not necessarily. Computer work, because we're in Pennsylvania, it has to be somebody who is a highly technical person who is working, developing your programs, modifying your programs to make them fit your operational needs. It can't be somebody at the help desk or tech desk. And then if you are setting policies regarding safety, if you're negotiating safety, you're showing up to workers' comp hearings, you're showing up to EEOC hearings, that too can be a compliance aspect that would qualify for the administrative. And then this concept of exercising discretion and independent judgment, we'll tick through those, but do you have 2 or 3 or more of these ability to exercise discretion and independent judgment? Are you formulating policy, carrying it out, advising the management committee of a significant direction or policy? Do you have the ability to commit the company in matters of significant financial impact? Can you say, you know what, I'm going to waive or deviate from this policy because it's not operationally sound or it doesn't benefit the business? Can you negotiate at the negotiating table? Or do you provide expert advice to management, such as an accountant or some other kind of advice to management or to your company's customers? Do you investigate matters of significance? And we talked a little bit about handling arbitration disputes. So what the Third Circuit looks at is, do you have 3 or more of these categories in your toolbox as essential job functions? Then yes, you can meet this administrative exemption. And so here are some of the positions that we see: tax, insurance, QC, purchasing, advertising, human resources managers, executive assistants to senior managers, and legal and regulatory compliance folks. Learned professionals we'll go through real quick. It is somebody who requires an advanced degree or advanced knowledge in a field of science or learning. Think law, medicine, theology, accounting, engineering, teaching, generally a prolonged course of specialized training or intellectual instruction. So it's not on the job training. It's high school degree is not going to be enough. Even sometimes a bachelor's degree is not necessarily enough. And then no more than 20% of their time can be spent in non-exempt duties. So here we have RNs, dental hygienists, physician's assistants, accountants, executive chefs, engineers, funeral directors, but not paralegals, not cooks, not LPNs, not HR generalists. And then finally, the outside sales. We do have this in Pennsylvania. It's very similar to the federal outside sales exemption, but really 80% of your time as an outside salesperson needs to be outside the office, outside your home work environment if you're working remotely, on the road, engaging in and writing contracts for sales. The promotional work, the writing of the ticket orders, the purchase agreements, whatever, that can be part of that work as well. But you have to be mindful of being out on the road for a significant period of your time. Another area that we're going to see change, and we might see this change come about more quickly. And why? Under the Biden administration independent contractor reg, we saw a shift away from the more employer-friendly Trump administration independent contractor rule around the right to control, okay, and the economic relationship. And the Trump administration said, you know what, the right to control is the paramount consideration here. These others are kind of secondary considerations, and the Biden administration, and in fact, our Third Circuit, which is consistent with the Biden administration, says, no, 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 no. You need to look at all of these 6-factor economic realities tests when you're determining whether somebody's an independent contractor versus an employee. We might see under the Trump administration a shift back to that old independent contractor test that they had put in place, which really does focus on the nature of control over the right and day-to-day work activities of the employee. And some of these other things as to, you know, who provides the tools, who invests in them, are they engaged for a short period of time, or is it really essentially an at-will employment relationship? That those are secondary factors. But right now under this test, and we do see quite a bit of litigation here, it is a 6-factor test. I want to talk a little bit about the independent contractor risks, right? So before we leave that, sorry, there have been some recent cases that are significant. In June of 2025, or I'm sorry, of 2015, we did see a settlement involving FedEx, resulting in a $228 million settlement. That goes back basically years and years and years of litigation back to 2000 over misclassifying California drivers as independent contractors. You also saw the driver litigation of independent contractors versus employees with Lyft, with Uber, and the Uber cases resolved in settlements of 8.4 million and 20 million in California. So these are significant settlements, and they're significant kind of bet the farm, if you will, litigation if you've got a significant number of independent contractors in your workforce. You know, you want to be following those independent contractor rules and how they change. And then, as Kristen mentioned, you also need to keep your eye on the ball of the state minimum wage increases. Delaware, I'm kind of look at our surrounding states here. Delaware's minimum wage will reach $15 on January 1, 2025. Then New Jersey, to our east, effective January 1, 2025, we will see the minimum wage increase to $15.49 per hour for larger employers with 6 or more employees. New York State is kind of a kaleidoscope of minimum wage depending on where you are, and also depending on what industry you're in. But the general backstop of minimum wage in New York State is $15.50 per hour effective January 1, 2025. Some of the Manhattan boroughs, some of those closer to the New York City, you will see a higher minimum wage there. And then to our west, Ohio. On January 1, 2025, Ohio's minimum wage will increase to $10.70 per hour for employers with gross receipts in excess of $394,000 per year. So trying to target those larger employers. Where we did not see a minimum wage increase, shockingly, was California. California voters rejected a ballot measure to increase the state's minimum wage up to $18 per hour. That was the first time in 28 years that a ballot measure to increase the state minimum wage was defeated. So while California's minimum wage is still among the highest in the country, the voters moved to reject a higher minimum wage to that $18 threshold. I wanted to speak very briefly about remote workers and echo Kristen's kind of red flag here. Remote workers, depending on what they're doing for you and whether they're actually reaching out to the state in which they are working, could determine whether you're actually doing business in that state, and you might need to register to do business in that state. And the waterfall of that decision would be, well, do I need to be paying payroll taxes to that state? And does that state have a paid sick leave or a paid family leave benefit that I need to be either affording to my employee, or do they have kind of an unemployment type of arrangement where you pay into part of the wages into a state fund in order for the employee to take advantage of that at some point in time? So we can't just simply say, well, somebody set up shop and they're working remotely, out of their home in a different state anymore. We may need to be mindful of what they're doing. Are they reaching out to the state? Am I conducting business? And do I need to register with their payroll? And do I need to be mindful of these paid sick and paid family leave measures in those states? And finally, we went through a whirlwind here in the time allotted. Thank you for that. I wanted to just mention next, let me see if I can get to this. So the next topic that I wanted to cover is, is the future of the federal contractor minimum wage. We just saw a challenge to this on November 5th. The Ninth Circuit Court of Appeals, which is in California, vacated. So this is a theme that we're seeing, a district court decision that found that President Biden did not have the authority to increase the federal contractor minimum wage, which was set to go up on January 1st of 2025 to $17.75 per hour. And the Court of Appeals vacated that decision and said that they do not have the authority under the Procurement Act to implement that federal contractor minimum wage. So if you do have clients or you are a federal contractor, that put a pause on that increase in the federal contractor minimum wage, and we'll have to see how the Trump administration handles that. And then I'm not going to go too much into this concept of AI because our next team of Greg and Micah will be dealing and diving into that for you. But I do want to let you know that not only is the EEOC and some of the other agencies, which Greg and Micah might talk about, getting into this AI game, but also the Department of Labor has issued guidance on artificial intelligence for employers as well. It's a bit more generalized, but it focuses on almost your internal process and mechanism that companies should have if they're going to go down this path of implementing and using AI, most likely in hiring decisions, as you'll probably hear Greg and Micah talk about. But do you have a governance and oversight function that can look at how AI might impact all of the aspects of your business? Are you transparent in telling your employees how you're going to use AI and maybe some of the data and some of their information in that process? Always concerned, the Department of Labor is about protecting labor and employment rights. So anything that you implement from an AI perspective shouldn't undermine a worker's rights to organize, to your health and safety efforts, to pursuing wage and hour rights, anti-discrimination and anti-retaliation rights. This is the link if you want to find this best practices. And it should enable workers to do better at their job as opposed to elimination of jobs in the AI and technology sphere, and ensure that any of the data that you're collecting as a company that feeds into this AI system and use of AI, think hiring decisions, things like that, should be narrowly focused on a legitimate business interest, and it should be protected from a confidentiality perspective. So with that, I was 1 minute over, but I hope you enjoyed that whirlwind tour of the wage and hour and Department of Labor spotlight and a little bit of reading the tea leaves going forward to the best that we can.